All right, in this video, I'm going to break down the COPA v. Wright appeal decision from the High Court, Her Majesty's Court in the UK. Just came out today, November 29th. So stay tuned to the end and we will share it, break it down. Okay, so let's get started. Rule 52.61 provides that a permission to appeal may be given only where A, the court considers that the appeal would have a real prospect of success, or B, there is some other compelling reason why the appeal should be heard. Where the permission appeal has been refused on the papers, that decision is final and cannot be reviewed further or appealed. See Rule 52.5 and 54.4 of the Access to Justice Act 1999. So those are the relevant provisions here. So let's cruise on up here and take a look at it. Order made by the RT Honorable Lord Justice Arnold on consideration of the appellant's notice and accompanying documents, but without an oral argument in respect of the application for permission to appeal. The decision. An extension of time for appellant's notice is granted. 2, application for permission to adduce fresh evidence, all refused. Permission to appeal, both refused, being totally without merit. Now, they were court granted an extension of time exception due to a technicality, and that was granted. So basically, there were 2 separate appeal briefs, and one was after the other. So it was of no fault here for Dr. Wright for filing the second one late, they said, and it was no prejudice to the other side. So permission to adduce the fresh evidence. Dr. Wright requested that additional evidence be put in. So it's under the standards of Ladd versus Marcia criteria, and none of this evidence satisfies those criteria. So he wanted to put in Dr. Jones' affidavit, Mr. Mayaka's affidavit, Dr. Savannah's affidavit, expert evidence, and also judgment in another case. This evidence is not evidence at all. In any event, Ager Hansen did not give evidence in this case. Thus, the judgment would make no difference to the judge's reasoning. So the Mayoka evidence admits that the lawyers interviewed Mr. Mayoka before trial, and they decided not to adduce his evidence from him. So Dr. Jones gave evidence at trial, and so the evidence could have already been adduced in the event that it made no difference to the judge's ruling. Expert evidence here, the evidence could and should have been obtained before trial. This judgment, was not relevant, and thus the judgment would make no difference to the judge's reasoning. Mr. Cohen's draft witness statement and related documents, Dr. Wright admits that his legal team decided not to adduce this evidence at trial. Furthermore, the draft statement is unsigned and described as very much a working draft. Draft 4 witness statement is of Dr. Wright and related documents E, in so much as this evidence was not adduced at trial, it plainly could have been, given the draft statement is unsigned. Dr. Wright, so given the judge's credibility. Again, admission of this evidence would have given rise to issues on waiver of privilege, and it would not make any material difference anyways. Matters concerning Mr. David Pierce. All this evidence shows that, 1, the judge discussed the time when he hoped to be in a position to hand down the judgment with Mr. Pierce at a social event sometime before the 9th of March 2024, 9th of May 2024. And 2, the judge had had other conversations with Mr. Pierce about other topics. Given that the judge had already announced his decision on the 14th of March 2024, this does not demonstrate the appearance of bias, let alone actual bias. Nor would it have done so even if the judge had already announced his decision. As for this, it's wholly irrelevant, particularly given Mr. Pierce was not a witness. So that goes on to the bias standards here. Court apparently is ruling on that. All right, important to note here. Here's an important note here about what was decided. Permission to appeal. The judge had to decide a single question. Is Dr. Wright the person who adopted the pseudonym Satoshi Nakamoto, who wrote and published the first Bitcoin white paper on the 31st of October, 2008, who wrote and released the first version of the source code, Bitcoin source code, and who created the Bitcoin system? This is a pure question of fact. So this is the matter that was decided, and the determination was no. So the judge found that the answer to that question was no. He arrived at the decision after a 22-day trial involving a mass of factual and expert witness factual evidence, which the judge painstakingly analyzed in great detail in a judgment running to 945 paragraphs, together with an annex running to further 799 paragraphs. Neither figure includes the many subparagraphs. Among the key reasons for his decisions were that the conclusions that Dr. Wright had lied repeatedly and extensively to the court in his evidence, and two, Dr. Wright had forged a large number of documents which he relied upon in support of his claim. Overall, the judge concluded that the evidence that Dr. Wright was not Satoshi Nakamoto was overwhelming. In reaching these conclusions, the judge had the advantage of seeing and hearing Dr. Wright cross-examined for over 8 days on 15 statements. It is also important to note that Dr. Wright had the benefit of being represented at trial by 2 leading King's counsels and 3 juniors instructed by a substantial team of solicitors, and B, adjustments were made for Dr. Wright when giving evidence, which were agreed by the parties experts in ASD, and no suggestion was made at trial that these statements were inadequate or ineffective. The judge's decision can only be overturned or set aside if it is either wrong or unjust because of a serious procedural or irregularity in the proceedings in the high court. That's CPR 52.213. In order to establish that a finding of fact is wrong, an appellant must demonstrate that it is rationally insupportable. Volpe versus Volpe, 2022. Dr. Wright challenges the decisions on no less than 59 grounds, which attack almost every aspect of his reasoning. Upon analysis, these grounds amount to a primary case that the Court of Appeal should, in substance itself, retry the case on appeal and conclude that the judge was wrong, and on a secondary case, the Court of Appeal should order a new trial of the identity issue because the judge's decision was unjust due to a serious procedural or other irregularities, such as Dr. Wright was denied a fair trial. The primary case that the Court of Appeal should itself retry the case on appeal and concludes that the judge is wrong and is totally without merit, since it involves a complete misconception of the Court of Appeal's function and approach in a case as this. Furthermore, none of Dr. Wright's grounds comes anywhere near demonstrating that the judge's decision is rationally insupportable. As for this secondary case, this could, in principle, be a proper basis for appeal, in a case such as this. But again, it is totally without merit since none of the grounds come anywhere near demonstrating that the judge's decision is tainted by irregularity, particularly bearing in mind A and B identified above. On the contrary, Dr. Wright's grounds of appeal, skeleton argument, and summary of skeleton argument themselves contain multiple falsehoods, including reliance upon fictitious authorities such as Anderson versus the Queen, 2013, which appear to be AI-generated hallucinations. It is neither necessary nor proportionate to address each of these 59 grounds individually, but I will briefly consider each of them, the 10 main themes identified by Dr. Wright in his summary of skeleton argument. 1, misinterpretation and attribution of evidence. Dr. Wright claims that the judge misinterpreted various items of evidence and incorrectly attributed his documents. His assertions are either new points not raised at trial or contrary to the evidence or fail to engage with the judge's reasons for rejecting them. 2, judicial bias and procedural unfairness. Dr. Wright accuses the judge of bias, but his accusation is baseless. No credible allegations of either actual bias or apparent bias is made by Dr. Wright, but only a series of disagreements with the judge's reasoning. In fact, the judge bent over backwards to ensure that Dr. Wright received a fair trial. The same goes for the accusation of procedural unfairness. 3, improper rejection of expert testimony. Dr. Wright makes a number of challenges to the judge's treatment of the expert evidence. But as the judge explained, Dr. Wright's own expert agreed with COPA's experts on most issues. Having chosen those experts to give evidence, it does not lie in Dr. Wright's mouth now to say that they were not qualified, not appropriately qualified. Nor can Dr. Wright complain about decisions taken by his legal team with his authority, such as decisions not to call some witness and not to cross-examine others. Dr. Wright argues that the judge should have treated himself as an expert, but given that one, Dr. Wright was the principal factual witness, and two, he had appropriately qualified experts, the judge was plainly right not to treat him as a surrogate expert witness. Dr. Wright alleges that the judge wrongly excluded Mr. Bryant's evidence, but this is false. Dr. Wright did not pursue a late application to adduce this evidence. Dr. Wright claims that Mr. Madden was not properly qualified, but the judge explained why he was. 4. Reliance on unauthenticated reliance on unauthenticated documents. Dr. Wright argues that the judge improperly relied on documents that were not properly authenticated. This is a misconception. The true position is that the document is assumed to be authentic unless its authenticity is properly challenged. Dr. Wright's real complaint concerns a number of judges finding a forgery, but without engaging with the reasons given by the judge for these findings, which were largely based on uncontested expert evidence. 5. Inadequate considerations of Dr. Wright's ASD. Dr. Wright complains that the judge did not make reasonable adjustments for his ASD. This is a disability. This complaint is baseless. As noted above, the judge made adjustments which were agreed by the parties, experts on ASD, and no complaint was made at the trial level, and they were inadequate or ineffective. At the end of the cross-examination, Dr. Wright commented positively on the experience. A number of Dr. Wright's allegations under this head are simply false. Dr. Wright even complains that his own counsel intervened on occasion to ensure that Dr. Wright did not unintentionally waive privilege, when they would have been open to criticism if they had failed to do this. 6. Improper handling of cross-examination. Dr. Wright complains that his cross-examination was improperly handled by the judge. This is largely a repetition of theme 5. Misapplication of legal standards. Dr. Wright alleges that a judge failed correctly to apply a number of legal principles. These allegations are without merit. For example, Dr. Wright claims that the judge wrongly applied burden of proof. In fact, the incidence of burden of proof was common ground at trial. In any event, the judge's self-direction was impeccable. Dr. Wright also claims that the judge wrongly did not require COPA to present clear and convincing evidence for its allegations of forgery. But in fact, the judge did recognize that cognate evidence in support of these allegations was required, and he found the evidence was cognate and indeed, in many cases, unchallenged by Dr. Wright's own experts. Dr. Wright also claimed that the judge wrongly rejected evidence which corroborated Dr. Wright's claims. As the judge explained, however, a few of Dr. Wright's witnesses gave evidence which actually supported those claims, and he gave cognate reasons for rejecting the evidence of the few that did. The final example I shall address in Dr. Wright's claim that the judge wrongly accepted hearsay evidence. In fact, COPA gave proper notice that the judge accepted the evidence for good reasons. 8. Failure to scrutinize COPA's witness credibility. Dr. Wright alleges that the judge failed to scrutinize the credibility of COPA's witnesses. This, again, is a baseless allegation. In many instances, Dr. Wright repeats criticism for which the judge carefully considered and rejected, or which were not even put to the relevant witness because Dr. Wright's legal team appreciated that they were without foundation. Dr. Wright even complains about the judge admitting evidence from James Loop when Mr. Loop was not a witness at all. 9. Inconsistent application of legal principles. This is a largely repetition of other themes, in particular, theme 7. 10. Procedural irregularities and denial of a fair trial. This is largely repetition of themes 2 and 3 and 5. Dr. Wright even goes as to so far and say that his own legal team's failure to adduce evidence and or challenged evidence adduced by COPA breached his Article 6 ECHR rights. This is an impossible contention. Dr. Wright had the benefit of a large, high expert and well-resourced legal team which acted with his authority and presented his case as well as could be possibly presented. For those reasons given above, the appeals have no prospect of success whatsoever, and there is no reason to hear them. Information for the decision of the parties. So it just goes back into what I already read here, which is that signed by the court December 28th, 2024, Rules 52. So it provides that the permission to appeal may be only granted when the court considers the appeal would have a real prospect of success or there is some other compelling reason why the appeal should be heard. Where permission of appeal is to refuse on the papers, that decision is final, cannot be reviewed further on appeal. So that is final. That case is over. All right. So that's sure my overall review of this here. It's it's easy to play armchair quarterback and try to say, oh, he should have this, he should have that, or but ultimately, I'm just wanted to try to read that and give everybody's perspective. But the bottom line is that hats off to Dr. Wright for pursuing that case, because it was rather incredibly laborious and detailed. And he wasn't successful. You win some, you lose some. He lost that case. So he has a contempt hearing coming up for filing the passing off case. That's going to be on December 18th in London, where the court's ordering to appeal in person. The only thing that's relatively new in this case, I think that I wanted to add commentary on, is that at the last hearing on the contempt, the lower court judge, Judge Miller, he admitted that he did meet with the opposing, with Mr. Pierce at a social event. Now, that was before the judgment came out, but after the decision came out in the court. So he issued his decision on March, like you mentioned here. But then after the judgment came out, before the judgment came out, he met with Mr. Pierce at a social event. It wasn't just a social event. What came out, it was actually technically it was called COPA. I made an the last, the transcript said it was a COPA event. That's what the transcript from Mr. Pierce said last time, but it was actually a KIPA event. So, ultimately they're both about patents. They're both alliances about patents. They're definitely in support of COPA. They're similar to COPA. It wasn't an actual COPA sponsored event. Okay. That was an error by Mr. Pierce in his actual reporting when I read it. All right, apparently. But either way, it definitely created an appearance of bias if he's going to an event that's about patents, a patent event, and he's ruling on this patent alliance case. It's just, it sure doesn't look good. I wish the judge would have waited to go to that event till after he made his decision, wrote his judgment. I think that would have been more proper, than going out and going to social events about patent alliances, and then talking about the case. What did he talk about the case about? The court said this, other issues. What was discussed? We don't really know. I would say that at this point, Miller really should recuse himself from the case for that. It doesn't appear to be very, it has the appearance of bias. I get it. The Court of Appeal saying, oh, it's not bias. That wasn't properly really challenged. There's a procedure to apply to the court for appearance of bias. So that was on appeal, but the appeal was denied and this case is over. So it's water under the bridge at this point. So it looks like, Dr. Wright's going to have to decide if he's going to appear at the contempt hearing or not, or if he's going to challenge it on a application for disqualification of that judge, Miller, on the new facts that have come out now about potentially going to a COPA event, KIPA event. What was it? That's just again, it's not about actual bias. It's just appears to be bias. It just appears to be, as a member of the public, he's going to an event that's kind of sponsored that's kind of involving the other party. Kind of, is it? Maybe. I don't think it's a good idea to go to that event, especially if you're going to talk about the case at the event. I don't think I just think that appears to be, he only talked about certain things about the case. It doesn't really matter. He shouldn't be talking about the case before he's writing the judgment at a public event or at kind of a private event, which is about patents, and the other party's about patents. So anyways, it just appears to be bias. I wish the judge would have waited for that. That's my only perspective. So just for the integrity of the court, he really should recuse himself. Miller should, and step down and let somebody else, do whatever they're going to do about the contempt hearing, because it was unprofessional for Miller to do that. I think, out of the integrity of the court, he really should, he should step down, and let somebody else, decide on the contempt stuff or however it works. just out of respect for the integrity of the court, not Dr. Wright, integrity of the court. All right. Dr. Wright loses the appeal. Are there going to be any more twists? If Miller does recuse, that's a huge twist. Anyways, all right. Hope you like this video. Hit the like button. Wanted to read through it and just overall give a little commentary at the end. Everybody just hear it without commentary, and then at the end put a little in there. So hit the ones, subscribe. I'll see you at the top. Later.